So Kirby Drake is going to speak now. She was scheduled a little bit earlier, but thank you for your flexibility. So she actually drove down from Dallas to be here today, and she is the founder of the Kirby Drake Law PLLC. So she is a registered patent attorney, and she's also the former chair of the State Bar of Texas of Intellectual Property, as well as the Women and the law section. She's the member of the Patent Advisory Board for Texas Accountants and Lawyers. So please help me to welcome Kirby Drake. Thank you so much.
Thank you, Maya, and yeah, thanks to everybody. Hopefully, hopefully it didn't mess anybody's time schedules up because hopefully you're interested in this, and we can give you some good information here today. So I'm here, I would say, in two capacities, and what this presentation is going to cover is mostly related to patents, but as Maya said, I am a registered patent attorney, and so I do lots of patent work with my law firm. But one other area that I spend a lot of time with is this group called Texas Accountants and Lawyers for the Arts, and Justin is also on the on the board for Tala, as we refer to it. And so what I want to take a little bit of time in this first part of the presentation is just to introduce you a little bit to Tala. And then as part of the second part of the presentation, we'll go into some of the specifics about what you need to be thinking about or what kind of information you need to be pulling together if you are going to pursue a patent application, whether it's going through Tala if you qualify, with the financial requirements and the like, or if you were just going to work with a patent attorney or agent, or possibly file it on your own. So hopefully this presentation, regardless which path you're considering, will give you some of those key considerations that you may have already thought about, or you may need to think about if you're deciding whether to pursue patent protection. Let's see. Let's see. Oh, oh, there it goes. It was a little slow. So just to give you a little bit of an introduction to Tala, Tala's been around for a long time, since 1979, and it was originally founded to, and as the name suggests, was to help related to artists and art centered nonprofits, and provide some legal assistance as well as accounting assistance for those types of organizations. And so Tala, provides a lot of different services on that side, but over time it's evolved to also take on the patent pro bono program, as we're going to talk about in just a minute. But the mission and the vision of Tala is that we believe that individuals, nonprofits, should be able to to get access to this knowledge and guidance, to further their endeavors regardless of their income. Up. And of course I went backwards. Let's see. There we go. Yeah, so as I mentioned, this presentation I'm doing today is not going to particularly focus on the artist and nonprofit side. If you are interested in that, and I think Justin will be around. Justin's been very involved on that side of Tala for some time, and can probably address specific questions from the art side if you're interested in that. But it as the name says, we do provide legal and accounting services to individual artists as well as to nonprofits, in all the different areas. So generally that would include things like copyrights and trademarks that you're hearing about today. And we do serve a lot of clients each year on this side. So some of the topics that are typically covered on that side, you see up at the top, it'd be copyrights and trademarks. Sometimes it can be, contract drafting. It could be other types of agreements, helping you form your entity, to do art related work, incorporate a nonprofit. Some things related to accounting. But then, we don't do don't do things that more general legal aid or legal assistance groups may provide. So things related, specifically to family law, criminal law, things like that. If you're looking for those kinds of services, there are legal aid opportunities in each city and area that you could seek assistance from if you need that, and can't may have difficulty paying for an attorney to help you with them. So, but specifically for inventors, we partner with the United States Patent and Trademark Office, and I'll refer to it in this presentation generally as the USPTO or the PTO, as you see up here. And our goal is to assist financially under resourced inventors here in Texas. So we're focused on making sure that inventors that may not be able to hire a patent attorney or agent on their own, maybe too early in their involvement, may just have other reasons why why they can't go out and procure legal services on their own. That they have somewhere to go to talk with a patent attorney or agent about their invention, make sure that they've got things in order to be able to proceed with possible patent protection, and then have the assistance of a patent attorney or agent volunteer to prepare and file that application and potentially help you through the whole patent protection process. So we do all of those things as part of Tala, and this is specifically on the Patent Pro Bono Assistance Program. So just a little bit about the Patent Pro Bono Assistance Program. We've been doing this for since 2016 as part of Tala. The Patent Pro Bono Assistance Program has been in existence in Texas prior to that time, but it came under the umbrella of Tala in 2016. So we've been doing this for a number of years here in Texas, and we've matched many inventors with patent attorneys and agents for all different types of patent filings. We also, and I'll talk about it in our process in a minute, we also do patent clinics, generally on a quarterly basis, where inventors have an opportunity to have a one-on-one meeting with a patent attorney or agent volunteer to talk through their invention, get any questions answered that they may have, and then we use that as a screening process to have you enter into the Patent Pro Bono Assistance Program after a clinic. This just gives you, wide a number of examples of different inventions that have been matched through the Patent Pro Bono program. As you can see, it's basically anything and everything. So we're not limited by, the type of technology or the industry. Generally, we have patent attorney and agent volunteers that can help, regardless what type of area you're seeking to get patent protection in. So just some of the demographics. As I said, this is intended to be a program that helps financially under resourced inventors to move forward in the patent process. But just generally, we are serving underrepresented communities. A lot of our this is just an average income of a 2.1 household size, but the thing to keep in mind, and we have all of these, all this information available on the website. But if you do want to receive pro bono assistance through the patent program, we just have a requirement that you show an income of less than 300% of the federal poverty level, and that's set by Health and Human Services. So it may change over time, but all of that information is available on the website. So this just gives you some of the breakdown of member qualifications, and this would be both for artists as well as inventors. You have to be in Texas. So from what Sarah her polling this morning, I think pretty much everybody would would meet that qualification. We have these are just the general household income limits. If you are a nonprofit organization, then we have some annual budget and asset limits, but there is an application fee, for artists, for inventors, and for nonprofits, and they are slightly different. On the on and I'm less familiar on the artist side, but on the artist side, because you can make multiple requests, that application fee is considered to be an annual fee, And but on the inventor side, because you may only be doing, one patent application, it is a one-time fee to enter into the patent program for that invention. If you came back to Tala with a second invention that you wanted to protect, then there would be a second fee for that. So essentially a processing fee. But if you're just coming with your one invention and that's what you want to work with Tala on, then as an inventor, you would just have the one time fee, and then we have the nonprofit fee, which would be more like the artist side because it's dealing more on the art side of things. So as I said, this is just a high level explanation of how the Tala patent pro bono process works. And so starting up here, we have a what we would refer to as a screening process. And if you've been screened, then that generally means that you didn't have a provisional patent application already on file. Then you participate in one of those patent clinics that I referred to in order to have a meeting with a patent attorney or agent volunteer to go through your invention and for them to essentially provide their comments on whether they think you're ready to move forward in the patent process. So assuming that you pass through that screening and you meet the financial requirements, then you'd be invited to join Tala and proceed through the next steps of the process. Um, so uh, so if you'll join Tala, and then if once we have your invention, so you have a form that you fill out on that, then you get automatically placed on the case list that gets sent out to our attorney volunteers once you're accepted into the program. The list is sent out to our attorney volunteers, and if they identify a case, so they identify your case that they're wanting to volunteer on, then they'll respond to the correspondence from Tala. Then a notice gets sent saying you two have matched, and then the inventor can then is given the information for the attorney to contact to begin the process. So the other part to note on here is, while our patent services through, if you do it through Tala, they are pro bono. So, you're not paying, fees for the lawyer's time in preparing and helping you through the patent process. You are responsible for the government filing fees that are associated with the patent protection process, as well as if there are drawing fees or other fees that are associated with essentially your hard costs related to the patent process. And that's something that the attorney volunteer that you work with will walk you through and make sure that you're clear on as you move forward, so you have an expectation of what you're responsible for, and so you can make the appropriate plans for that. So now I'm going to go into this is the part where while I'm walking you through it with respect to essentially Tala's process of evaluating and helping you move forward in the patent process. This part is something that even if you're not going to move forward with Tala, even if you were going to go and work with an attorney or agent that you were going to pay, or you decide that you're going to try to um, you know go into the patent process on your own, hopefully this will provide you with some information that will guide you and help you um, to move forward a little bit easier than if you're just going into it cold. I would say, if you were going to do it on your own, or even working with an attorney, everything that Sarah talked about with the Inventors Patent Academy, all of that would be, really beneficial information for helping you put together some of this information around your invention if you decide to go that route. So what I'm showing you here, and what we'll show on the next couple of slides um, are some of the parts of what we refer to as our patent disclosure form. And so this is a form that before you show up for one of the quarterly patent clinics, and to let when I say show up, we do it all online, so you don't have to travel anywhere. You can be anywhere in the state and join one of our patent clinics. So we try not to limit it to physical locations, enabling it to be accessible to everyone. And you can join one of our patent clinics regardless whether you actually think that you're eligible to join Tala as an organization. like if if you're questioning whether you might meet the financial requirements, or you don't meet the financial requirements, but you're just wanting an opportunity to have some questions answered by a patent attorney volunteer, you can always join a patent clinic for that thing. You don't necessarily have to be pre-qualified to to join Tala to be able to benefit from the clinics. But before each of the clinics, we provide this disclosure form to to inventors that are going to be part of the clinic, and we encourage you to fill it out as a guide to facilitate your discussion with the attorney volunteer, because it'll also help you to figure out where are the gaps in my information. What do I still need to collect? What might be missing? Or what am I what are my questions about the patent process? So hopefully, some of these things will trigger something in your mind that if you're coming to the clinic, then you have an opportunity to ask questions about it, because you don't submit the form to the volunteer at the time you're at the clinic. It's meant to be a guide for you, and hopefully, if you do get matched after the clinic, assuming you join Tala, then that form is extremely beneficial to the volunteer that's going to help you, because you'll have already collected the information that they would need, which will hopefully streamline the process to start proceeding with the patent protection. So I'm just going to walk through these things. First part is just kind of giving a high level, description of what is this invention all about? What am I, what field is this in? And so we give an example here. So if it was power supplies, you'd say, it's generally related to power supplies, but it might be more particularly, control circuits for power supplies. Or if you said, my area is beauty products, and so it'd be beauty products, and more specifically, cosmetics to help with the aging process, or something like that. So really high level, so that we have context for what field or what technology is this directed to. Then you have a second part that is the summary of the invention, and this is where we're asking you to just kind of summarize your invention in about a paragraph, giving a high level description of the invention, some key features, and essentially trying to tell, if you were going to tell someone what's new and different about your invention, this is where you would put that information. So this is not the complete description of your invention, but essentially if you're thinking about a paper that you might write, or if you look at a patent, this might end up being the information that would eventually become part of the abstract, so the high level summary of your invention. Then you're going to explain the problem that you're trying to solve through your invention. So we ask that you consider providing a couple of sentences that are explaining the problem that your invention supposedly solves. So it could be explaining, what's been done in the past and what you're trying to improve on, or just generally how your invention is solving some sort of problem. And this helps us to just get context for what those new and different things might actually be related to your invention. Then we have this bigger part, which is what we refer to as the detailed description of the preferred embodiment. And this is where you're going to explain, how do I use my invention? How is it put together? Um, Kind of what's the best way that I know of for providing this invention. And then you see underneath, we do have another section where there's alternatives. So you may have a situation where you've created a particular product that is put together by, you think the best way of putting it together, or having things. Let's say maybe a piece of clothing. You said, my best way of doing this would be that I use Velcro, for how the I don't know, how the garment, the piece of clothing, parts of it fasten to one another. But you look at it and you say, well, you know, Velcro may be the best way that I know how to do it, but for the way that I've constructed this, I could also use buttons. I could also use a zipper. Other way there could be other ways to fasten it than just the one that I'm particularly focused on. And those are what your alternative embodiments would be. So you can kind of use that as your brainstorming of there could be different ways to do it, and we want to start thinking about all those different ways. It also could be if you're thinking about, I could use my invention in this particular field, maybe it's something that you've directed to the medical field, but you'd say, "Oh, but it could also be used in, I don't know, agricultural, uses," so other applications beyond maybe the field that you're specifically focused on. And then we have a section on prior art. And what prior art is that, these are the things that came before your invention. So sometimes it could be things that you found on the internet. It could be other products that you already know about. It could be patents or other publications that talk about what people have done in the past. And so what we want to know is, have you looked at those things? And if so, tell us about it so we have the context for it, because the patent office will require that anything that we know about that came before your invention but has relevance to your invention, we have to disclose to the patent office. And so this is a way to prompt you to start thinking about what are those things that I've searched either formally or informally that might be helpful. It also could help in drafting an application. So you're not required to do a search, but if you do a search, then we want to know what what the results of that search were. And then drawings, figures, drawings. Not all inventions require figures or drawings, but if you do have drawings, and these may not be professional drawings, they may not be done out of, computer programs. These may be hand drawn drawings. They could be photographs. They could be, just sketches of some sort. Flow charts, diagrams, anything like that that would help somebody to understand what your invention is about. That's information that you want to collect. So generally with the patent application, we only need, you know, if a drawing is required, there only needs to be at least one drawing, but often multiple drawings and kind of showing different views or how it's being used may help to show how different components of the invention are working together. Prototypes, I think, Carlin was asked about that. Not required to have one, but if you do have one, we like to know about it because that may help in, walking through and describing your invention better. You may want to bring that prototype if it's something that can be brought. You may want to take a video. I've had that happen a lot lately, where, it may not be something that you want to physically bring into the office to meet with the patent attorney, but if you have a video that you can share that's showing how it's being used, that may be helpful to the process. And then finally, there are some critical dates that we have to consider, and these are things that, I'm not going to go through all of these in detail today, but could be relevant to, like, how quickly we need to start the patent process, who you've disclosed it to. As Carlin said, if you've publicly disclosed it, there is something that is, in the U.S. law that could require you to have, to file your application within 1 year of that public disclosure or an offer for sale or an actual sale of your invention. And so we want to know about those things because it may say, as much as we want to help you get a patent, maybe the timing is off and you've missed your opportunity to get a patent, or you've taken some step, and we need to make sure that we file the application to kind of meet the requirements of the timing that you've set up. So these are just some questions to give some dates, allow you to discuss those things with it, and these would be things that quite often, a lot of my clinic one-on-ones will be discussions about these dates, to try to figure out, is this important, or, was this actually a public disclosure or not? And so, that's something that our attorney volunteers are familiar with and regularly handle, questions on those fronts. So then in this last part, I'm just going to walk through some of the terms, and you may have heard of these before, and I think Carlin mentioned some of them. So I'm just going to go quickly through it. But she said, we do have, typically with Tala and with most patent applications, you're either looking at a utility patent application or a design patent application. There could be some inventions that could be protected through both utility and design applications, but usually it falls within one of these two categories. Third one being plant patents. I have only had one client in my 20 plus years of doing this that had a plant patent, and I did not help them with it. So I know people that can handle it, but just it is a very, very specialized and very lightly used area of of patent law. But utility applications are protecting more of the functionalities, the things that are not ornamental. Whereas design patent applications are going to protect more ornamental aspects of things. Sometimes it can overlap with trademarks because you may have, as I think as Carlin mentioned, your shape of the Coke bottle. Perhaps that is trade dress for Coca-Cola, but at one time, they could consider, or they may have, I think they may have even filed design patent applications, to try to protect that unique shape of their, shape of it. And the important part on that is that it has to be ornamental. It can't, the way that it's shaped needs to be just for the way that you want it to look, and it's not about being shaped in that way to perform some sort of function. If it's shaped that way to perform a function, it's probably going to fall more in utility. We also have provisional and non-provisional applications, and we don't have a we could spend a lot of time talking about this, but just kind of the key takeaways on it is that you can file a provisional application. This is a much less formal application. It's a placeholder. It's not examined by the patent office. You're given an application number at filing date, your patent pending, but nothing's going to happen with it unless you file a non-provisional, which is the formal application. And you can file the formal application as your first patent application, or you can file it within 1 year of filing the provisional and say what claim priority back to the provisional, meaning that you needed a little bit more time to get it into a better form, or do some more research, perform some more tests, evaluate the market. And so there's a lot of different reasons why you might choose to start with the provisional. But if you start with the provisional, you've got to file that non provisional within 1 year, or else you're just going to lose out on the benefit of having filed the provisional in the first place. So a couple of things here. There's lots of different filing requirements with utility patent applications. We have things that we call, application data sheets, inventor oaths. We have filing fees, of course. There's a written description. You have to have at least one claim, and then those drawings. I'll highlight a couple of things here, and I will say on the Tala website, if you go to the inventor page, and I have the website at the end of this presentation. If you go on there, I have a longer presentation on our YouTube channel that goes through a lot of these details, much more, since I was trying to focus this presentation more on, what our services are. But if you're looking at more of the nuts and bolts of kind of what goes into the patent process, I encourage you to go check out that video. It's not much longer than this presentation, but just focuses in on those details a little bit more. But the key thing with the inventor oath or declaration is this is just saying, I agree that I believe I'm the first inventor of this invention, and you need to file it with your non-provisional application, or else you get charged a late fee. So that's the that's the thing is, if you're working with an attorney or agent, they'll prompt you to do that because they're not going to want you to be charged that late fee. Try to keep your costs down. Fees, there's lots of different fees that the patent office charges. Searching, examining. We generally file everything electronically, but if you do qualify, and generally most of the people that are eligible to enter Tala Patent Pro Bono Assistance Program would qualify as micro entities, which means that all the fees, or most all of the fees, are reduced by 75%. So it's a significant decrease in the fees. There are also most if you don't qualify as a micro entity, most individuals, would fall within a small entity status, and so you would still get a 50% reduction. But just to give you an idea, right now when you file a non-provisional application, you're going to be required to pay the filing fee, the search fee, and the examination fee. And so I've put the numbers up there currently for a micro entity. And then hopefully once your patent issues or is allowed, then you have to pay your issue fee for it to actually issue as a patent. And currently that's $258 for a micro entity. So that gives you some idea of what you're planning for in terms of government fees that would be involved. Maintenance fees. There's also maintenance fees once your patent issues. They're due 3 times over the life of the patent. There are still discounts that are available with those. They can be paid online. You have to pay those, or else your patent's going to go abandoned or expire. It doesn't mean that your patent is taken away as if you never got a patent. It just means that it's not enforceable against somebody else or licensable to someone else if it's no longer active as a patent. Let's see. Oh yeah. So then finally, just a couple of things, a couple of points here. Um, kind of misconceptions or things to think about in the patent process is that you always want to keep in mind, and I see a lot of times people will refer to a provisional patent, and that is not a correct terminology. What you have is a provisional patent application if you file that. And that does not mean you have a patent. That just means you've started the patent process. You've got to file that non provisional patent application within 1 year for that provisional application to mean anything. So if you file the provisional application, you're patent pending for that year, but you don't file the non provisional application, you're no longer patent pending. You've kind of lost out on the patent process related to that provisional application. We always want to make sure, and with that disclosure form information that I mentioned, that's how we ensure that the description that you provide is sufficient. As Carlton said, you have to put enough detail in to show somebody how to make and use the invention. And so we use these questions and getting all this information to make sure that the description is sufficient. Patent claims, didn't have time to go through those here today. That's the part that even if you're not, even if you're going to try to write up your own description or pull together your own drawings, putting the patent claims together for a non-provisional application it's really important that if you can work with an attorney or agent to do that, you should, because that's the part that's going to define the boundaries of your invention, and that's the part that the patent examiner is really going to focus on. Prior art, we have to know about it. If you know about it, we need to know about it, so we tell the patent office about it. But we don't have to describe it in a lot of detail. The patent office just wants to have those references in front of them to be able to consider when they're deciding whether or not to give you a patent. And then I already mentioned the on sale bar. That's what we kind of wrap up in that public disclosure, offering for sale, selling it. In the U.S., you do have up to 1 year after the filing or after one of those things takes place, generally to be able to still file a patent application. But that's why we ask for those dates. So finally, I did want to mention just another plug with Tala. We do a lot of presentations. We do if you follow us, if you get added to our mailing list, we have many free and open to the public seminars, both in person and online, all around the state. We had close to 2,400 participants in 2024 in all of our different programs. We do lots of community outreach, including the patent clinics. You can sign up for our newsletter to get those announcements. And then I mentioned the website. So talarts.org /inventors. That will take you straight to the inventors page, which you can see the link to the YouTube video as well as some other information if you're interested in joining one of our patent clinics. If you just go to talarts.org, if you're interested on the art side or nonprofit side, you can get that information. And our executive director, Elisa McCain, and our legal director, Angela Lee, are always happy to answer questions if you have particular questions about the TALA program. So I think that does it for me, and I'm I don't know, if you have I know I gave you a lot of information, and and so I'm happy if there's if there's a question right now, but I'm also going to be around here afterwards if if you have specific questions because I want to make sure we stay on track for concluding. Sure. Oh, you just can grab the microphone.
Who was it? Yeah.
Are the design patents subject to maintenance fees?
Is a what patent?
Design.
Design, no. You're
Okay.
good question. Yes. Yeah. So with design, you pay an issue fee and it has a shorter patent term than a utility patent, but no, there are no maintenance fees on a design patent. So once it's issued, it's good for the life.
What is the life of a
It's 15 it currently it's 15 years from the issue date. Um which is interesting because with the utility patent, they're measured from the filing date of the application, and so there's some time that can be added on due to delays of the patent office and things like that. But you get 20 years for a utility patent, but it's from the date of filing. But on the design side, it's 15 from the date of issuance.
are they is it possible to extend them or not? No.
No, no. It represents the bargain between you and the government is that you get a limited amount of time of exclusivity related to your invention, in exchange for it being essentially, the information in there being dedicated to the public after your patent term expires. So you get that 20 years or you get that 15 years, but after that, I mean, you could always file improvement patent applications, so there could be ways that you continue to protect further developments related to your invention, but as to that, that particular patent, it expires after that time and there's not a renewal.
So how did Mickey Mouse got its lifetime extension?
That's the copyright. Yeah. So yeah, and that's an interesting story. Yeah, they've found a lot of different ways to try to extend their extend their protection however they can. So, but yeah, that on copyrights, that's a whole different ball game. Oh, yeah, I think he's coming. Just take this one and then.
Hi, we have a tour company in Houston, and we create maps of different tourist areas
Mhm.
that we go to. And I wanted to ask, what's the best way to to protect our
Ooh.
maps and our tour routes from somebody just copying exactly what we do? Or is there a way to protect that?
Ooh, I think that may end up falling more in a Justin kind of category because I mean, if there were, if you had you know, kind of hypothetically, if you had you developed a particular type of software or something that you know aided in generating certain maps or tailoring them in some way, there could be something that is patentable, but generally on those kinds of things, and I kind of getting outside because I don't know where maps yeah, maps and charts are something that do fall into copyrights, but then you'd also have you probably also have some trademarks related to like the branding around your particular tours or particular offerings that you have.
So, from your answer, it doesn't sound like there's a good way to protect someone from taking what we do and all the research and work that we've done to create it and just copying it and doing the same thing.
You mean as a business overall? Is that what you're?
Yeah.
Yeah. I mean, I think that'd be harder. It's probably going to be more on an individual, kind of one by one, basis of those things, that could be protected through copyrights, but then otherwise, yeah, I mean, I don't think it's likely that it'd be something that could fall within patent protection unless you've got, particular technology that's assisting in making that happen.
Okay, thank you.
Great. Well, like I said, I want to make sure that we have time for the trademark presentation because I think that will nicely round out everything that we that we offer, and And but I will be around afterwards if you do have specific questions about about patents or about Tala or anything like that. So thanks so much.